Welcome to Glorious IAS Academy. Today we are going to discuss about the two important fundamental articles, Article 17 and Article 18. So, in the last class, we were discussing about the three important articles, Article 14, 15, 16. So, these five articles are part of the first fundamental rights mentioned in the Indian Constitution, that is right to equality. In last class, Article 14 is talking about the right to equality and equal protection of law. Article 15 is talking about the right against the discrimination on certain grounds, and Article 16 is talking about the right to provide equal opportunities in the matters of public employment. These three articles we have elaborately discussed in the last class, and some of the important judgments given by the High Court and Supreme Courts we were discussing about those things, and reservations are provided under the Article 16 and Article 17 provided certain exemption. By using these exemptions, the reservation provided to the SCs, STs, OBCs as well as the EWS communities. We were discussing about the Mandal Commission and etc. So in this class we are going to discuss about the rest of the two articles, Article 17 as well as the Article 18. Article 17 is talking about the abolition of untouchability. You might be knowing that what do you mean by the untouchability? Untouchability is a heinous practice that is meted out to certain sections of the society, especially in India. For example, if you take the case of scheduled caste and scheduled tribes, they were discriminated against the certain matters over the thousands of years. They were treated in a heinous way. Various atrocities were imposed, various atrocities are committed by the other sections of the people to certain communities like SCs. So, untouchability is practiced in many ways. For example, atrocity is the number one. Number two, denying the accessing to the public amenities like water facilities, like road facilities and etc. And also insulting them in the name of the caste, in the name of the class. So these are all comes under the practice of untouchability. So Article 17 is talking about the abolition of the untouchability. In Article 17, the government has the responsibility to make certain provisions, impose certain provisions, to implement certain programs in order to eradicate the untouchability. But the word untouchability is not clearly defined in the Constitution, but it is defined in various judgments that are given by the Supreme Court as well as the various High Courts time to time. For example, if you take the case of the Mysore High Court, the Mysore High Court is talking about the untouchability is not the literal meaning. If you should not take the untouchability in a literal meaning, in a grammatical meaning. Untouchability nothing but the more than that. It is the more than the literal meaning. It has wider scope. Insulting, discrimination, looking down, all these comes under the untouchability in the name of the class as well as in the name of the caste. So it is talking about is not untouchability is not literal and grammatical sense, but practice it had been developed over the hundreds of years historically in the country. And some exemption given under this Article 17 that it does not cover the social boycott of certain individuals or their exclusion from the religious practices. For example, a community belongs to certain religion but they are disturbing other practices, other religious practices. So they will be boycotted to adopt or to intervene that certain kind of the religious affairs. A Hindu should not interfere in the Muslim religious affairs. In that matter, those particular group would be boycotted from that practicing of that religion. So this is not comes under the untouchability. Untouchability is purely based on the discrimination in the name of the different things. So Supreme Court is telling about untouchability is available against the private individuals also. State should not practice the untouchability as well as any private individual should not practice the untouchability against any individual or rest of the others in the country. Suppose I cannot insult certain person in the name of the caste, that will comes under the untouchability. So the Supreme Court Given the wider expression to the untouchability, it imposed the restrictions not only the state as well as the every individual who is living in this country. They should not practice the untouchability. If they practice the untouchability, that would come under the offense under the Article 17. So, here disability arising out of the untouchability shall be considered as an offense, punishable offense according to the law under the Article 17. So, the phrase is not untouchable. Untouchable phrase is not clearly defined in the Constitution. It was defined by the various Supreme Court judgments time to time. Now, by using the Article 17, that is abolition of untouchability, government took some measures to eradicate, remove the roots of the untouchability in the country. Still, there is untouchability, and earlier we were practicing direct untouchability, directly insulting the people. Now, in today modern India, the shape of the untouchability had become attained in a different form. Now we are practicing different kind of untouchability, and let us not go into that details. So now we are going to discuss about what are the measures that has been taken by the government in order to eradicate the untouchability. The Supreme Court told the state government, central government, they should take some measures. State has every responsibility to eradicate the untouchability. So based on the Supreme Court judgment, time to time, the government of India has passed the certain kind of legislations. Parliament enacted the certain kind of acts. The first act is Untouchability Offences Act 1955. It was amended in 1976 and renamed it as Protection of Civil Rights 1955. It is very, very important. Earlier it was known as Untouchability Offence Act 1955. Now it become Protection of Civil Rights Act 1955. And what are the important provisions of this country? There are certain actions that will comes under the untouchability. First, if you prevent any person by entering into any public worship in the name of the caste, if you prevent any person by entering any place of public worship or from worshipping therein, if you deny the access to the Hindu temple, being a Hindu, if I become to scheduled caste, you cannot prevent me from entering into that temple just because of I belongs to certain kind of caste. You should not preventing from entering into that temple. So that is comes under the punishable offense under the Protection of Civil Rights Act 1955. Second one, the justifying the untouchability on traditional, religious, philosophical, on the other grounds. So by showing certain kind of the exemptions like traditional, religious and philosophical, you cannot practice the untouchability. And next one, denying the access to the shop, hotel or any places of public entertainment, whether it may be theaters, whether it may be restaurants, whether it may be anything, playgrounds. So you should not deny the access to these certain sections of the people. If you deny the access, that will comes under the untouchability. Insulting the name belongs to scheduled caste, and refusing to admit the persons in the hospitals, educational institutions and hostels, and preaching the untouchability directly or indirectly. These are all actions comes under the untouchability offences according to the Protection of Civil Rights Act 1955. Another important act passed by the Parliament, that is Scheduled Caste and Tribes Prevention of Atrocity in 1989. That first act is Civil Protection of Civil Rights Act 1955, and second one is famous name is SC/ST Atrocity Act 1989. So the main objective is prevention of atrocities committed to scheduled caste as well as the scheduled tribes. If I insult any person in the name of the tribe or in the name of the scheduled caste, scheduled tribe, I will be put behind the bars without any bail, without any non-bailable offences. According to this act, insulting any person or discriminating any person, if you practice the untouchability, that it is a punishable offence, number one. Number two, you will be arrested. Number three, without any police investigation, without any search, without any arrest warrant, police can arrest you and you will not be allowed to take the bail. That is non-bailable offences. But what happened after passing this act, some sections of the people belongs to those particular tribes and those particular SC/ST caste, and they are started misusing for their own personal usage, not because of the untouchability, for other personal grudges or for other personal benefits they are started using. This kind of judgments or this kind of negative thought is going on. Because of this disadvantage of this act, some people went to Supreme Court, and the popular case was Subhash Kashinath Mahajan case. In 2018, the landmark judgment given by the Supreme Court against this act, there are certain exemption given by the Supreme Court under this act. First, what? Supreme Court banned the immediate arrest of the people accusing of insulting or injuring a SC/ST member to protect innocent from the arbitrary arrest, and it banned the immediate arrest. But earlier it was police can arrest any person on immediate basis after complaint is registered in the police station. Next one, it is allowed the anticipatory bail, but previous before this judgment, the bail will not be allowed. The non-bailable offence, any offence committed under this act would be considered as non-bailable offence. Now Supreme Court allowed to take the anticipatory bail for those who booked for committing the atrocities against the SC/STs, and preliminary inquiry will not be required for the registration of an FIR against that person. Next one, there was a lot of criticism against the Supreme Court judgment, and some sections of the people and political organization, civil society members, there is a hue and cry about this judgment. So subsequently, in order to address this negative judgment, in order to address these agitations against this judgment, and Parliament had come up with the central government had come up with another act, that is SC/ST Prevention of Atrocity Act, Amendment Act 2018 Amendment Act SC/ST 2018. So in order to address the agitations, what is the agitations? Parliament has come up with the Amendment Act of 1989. So according to this amendment, these all provisions, all judgment will be abolished or cancelled by this Amendment Act. So finally, the Prithviraj and some of the people challenged this act in the Supreme Court again, and finally Prithviraj Chauhan case 2020 in Supreme Court held this act. So the Supreme Court allowed the Amendment Act of 2018. So all provisions, all previous provisions related to SC/ST Atrocity Act 1989 were restored successfully by Supreme Court in Prithviraj case. So next one, first Civil Rights Act 1955, second one SC/ST Atrocity Case 1989, and some of the provisions, and Supreme Court revised some of the provisions. Again government had come up with the SC/ST Atrocity Amendment Act 2018. Again it restored all provisions of the earlier act. So now we are going to discuss about another one, Article 18, abolition of titles. What do you mean by title? A title is a recognition conferred by the state authority to any person. For example, if you go into the British era, the British colonial state has conferred lot of different titles on the local jamindars. Rai Bahadur, Raja Bahadur, Maharaja Bahadur, Nawabs. So these are some of the very prestigious titles that are conferred by the British government on the local jamindars, local kings. So since they are very cooperative with the ruling of the British government prior to independence. So but after independence, the constitution inserted the Article 18 to abolish such a kind of the titles. So according to these articles, all these different kind of names, Raja Bahadur, means Rai Bahadur, this kind of the titles were abolished successfully. So what do you mean by this title? If you confer this title on certain person, and what would happen? That means you are indirectly giving certain kind of the prestigious to the people against the other people. Means you are conferring a title on certain person, means you are providing a special privileges, special status to that person. it is equal to inequality in the society. So in order to eradicate inequality in the society, in order to eradicate the false prestiges, in order to treat everybody in the society equally and everybody treated equally in the society, there should not be any titles conferred by the government. So all titles those who are conferred previously prior to independence, they were all are abolished under the Article 18. So what is that? Except military and academic distinction shall be conferred by the state. No title shall be conferred by the state. So there are four important provisions. Number one provision, this Article 8 prohibits the state government or central government from conferring any title. What are those exemptions? Two exemptions are given, military titles and academic titles. Military title means PhD, like that. Military colonel, captain, like those. Except those military and academic distinction names, all titles state will not allow to confer any title on anybody. Number two, no citizen of India, it also prohibits the individual or citizen of India from being accept any title from the foreign state. All citizens of India barred or prohibited from being accepting from the titles from the other foreign nations. First, state shall be prohibited from giving the titles. Number two, and no citizen of India should not accept any title from foreign state. Third one, those who are holding the foreigners, those who are holding the office of profit or trust under the state cannot accept any title from any foreign state without the consent of the president. Those who are holding foreigners, those who are holding the office of profit and trust, they cannot accept any title from any foreign state. But they can hold that, they can accept the title with the permission of the president. Without permission, without consent of the president, they should not accept any titles. And fourth one, no citizen or foreigner holding any office of profit under state and is to accept any present emolument, office or under any foreign state. So they should not allow any benefits from the foreign state. First one, state will not allow to confer any title. Second one, no citizens can accept any title from the foreigners. And third one, those who are holding the office of profit and trust, they should not allow accepting any titles from the foreigners except consent of the president. And fourth one, the foreigners, those who are holding public office of profit, they should not accept any kind of benefit from any foreign state. So these are the main provisions of these articles, Article 18. So if you look at here, hereditary titles of nobility like Maharaja, Rai Bahadur, Raja Bahadur, Rai Sahib, Diwan Bahadur, etc. All titles are banned by this kind of Article 18 under Indian Constitution. And there is a very, very important judgment given by the Balaji Raghavan versus Union. This is very important. In this judgment, Supreme Court allowed certain titles like Bharat Ratna, like Padma Awards. Supreme Court allowed these awards to confer on the citizens. Recently, Bharat Ratna conferred on certain renowned persons like Alke Advani, Padma Vibhushan given to the megastar Chiranjeevi, Padma Shri given to a lot of members. So this kind of the awards, Bharat Ratna, Padma Vibhushan, Padma Bhushan, KL Ratna, Padma Shri, this kind of the titles allowed, but except one condition, they should not use these title or suffix or prefix, and they should be fortified. If they use it, they should forgo the title, they should give the title back. So for example, the Sachin Tendulkar awarded the Bharat Ratna, he cannot use in any public document or anywhere Bharat Ratna Sachin Tendulkar. Like that, they should not use those titles, prefix or before the name or the after the name. If they use, and this title will be fortified, means they will taken back. So this is all about the Article 17 and Article 18. In last two classes, we have completed the first fundamental right, that is right to equality, Article 14, Article 15, Article 16, 17, 18. 5 articles covered under the right to equality, that is the first fundamental right of the 6 fundamental rights. Thank you very much.